Kerala Lawacademy Law College, in association for Advanced Legal Studies and Research (CALSER), is organizing a one-day international conference on recent trends in human rights and changing facets of religious freedom by a virtual mode on 7th August 2021 at Kerala Lawacademy campus, Perurkada, Trivandrum, Kerala.
The struggle for religious freedom has been ongoing for centuries and has led to innumerable but often tragic conflicts. Religious freedom, which is just one facet of human rights, has many dimensions and is ever-changing in a nation such as India. A nation which is the second most populous country in the world and the birthplace of 4 major world religions, has a long tradition of religious tolerances with periodic yet sometimes serious lapses.
This conference aims to highlight the different struggles for religious liberty present in our society and possible resolutions that can be brought forward to prevent instances of violation of human rights.
We, the Kerala Lawacademy Law College, heartily welcomes you all to the 8th International Conference.
Kerala Lawacademy Law College, in association with Center for Advanced Legal Studies and Research (CALSER), is organizing a one-day international conference on recent trends in human rights and changing facets of religious freedom by a virtual mode on 7th August 2021 at Kerala Lawacademy campus, Perurkada, Trivandrum, Kerala.
The struggle for religious freedom has been ongoing for centuries and has led to innumerable but often tragic conflicts. Religious freedom, which is just one facet of human rights, has many dimensions and is ever-changing in a nation such as India. A nation which is the second most populous country in the world and the birthplace of 4 major world religions, has a long tradition of religious tolerances with periodic yet sometimes serious lapses.
This conference aims to highlight the different struggles for religious liberty present in our society and possible resolutions that can be brought forward to prevent instances of violation of human rights.
We, the Kerala Lawacademy Law College, heartily welcomes you all to the 8th International Conference.
Religious freedom is one of the most fundamental of human rights because religious freedom comes from the dignity of human being as God's creature. These are the words of Suharto, an Indonesian army officer and politician who served as the head of the state and head of the government of Indonesia. The relationship between religion and human rights is both complex and inextricable. Religions provide the essential sources and scales of dignity and responsibility, shame and respect, restraint and regret, restitution and reconciliation that human rights regime needs to survive and flourish in any culture. Today, we are all gathered here on this virtual platform for the 8th International Conference on recent trends in human rights and changing facets of religious freedom, put forward by Kerala Lawacademy Law College in association with Center for Advanced Legal Studies and Research to understand the contributions of religion in development of the ideas and institution of human rights and the major issues and challenges that we face in tying the knot between religious freedom and human rights. Kerala Lawacademy Law College, established in 1966 by the legal luminary, late Dr. N. Narayanan Nair Sir, is a seat of excellence in legal education, research, and in pioneering law reforms. Kerala Lawacademy Law College is always in its constant effort for pioneering novel ideas. The Center for Advanced Legal Studies and Research is a research branch of Kerala Lawacademy Law College. A very warm good morning to one and all present here. Today, we are blessed with the presence of esteemed personalities on this virtual dais. Now, let's spend a minute in silence to cherish the memory of our beloved Narayanan Nair Sir. Thank you all. Before we begin our inaugural session, we have Gauri Jyotish B of 3rd Sem BCom LLB with a dance performance to commemorate Independence Day in advance. And here we go.
खुदा से मन्नत है मेरी लौटा दे जन्नत वो मेरी खुदा से मन्नत है मेरी लौटा दे जन्नत वो मेरी वो अमन वो चमन का नजारा वो अमन वो चमन का नजारा खुदाया लौटा दे कश्मीर दोबारा, ओ खुदाया लौटा दे कश्मीर दोबारा। चारों तरफ तो पहले सुकून ही सुकून था, आवाम को वतन से इश्क का जुनून था। चाहे खफन का छोड़ा मुझको पहना दे तू, मेरे बच्चे को वो जन्नत वो कश्मीर दिखा दे तू। वो मेरा रेगिस्तान बन गया शमशान, यह मौत की तहलीस पे खड़ा है हर इंसान, खड़ा है हर इंसान। मेरा कश्मीर, मेरा कश्मीर, मेरा कश्मीर, मेरा कश्मीर, मेरा कश्मीर, मेरा कश्मीर। हे 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 मेरा
Thank you so much, Gauri, for filling us with patriotism with your mesmerizing performance. To give a head start into our international conference, we have an audience poll conducted by Anaka S, student of 7th B LLB, on various questions that will help us understand the public opinion on the core of today's conference. And here we go.
We cordially invite each one of you to the 8th International Virtual Conference on the recent trends in human rights and the changing facets of religious freedom, organized by Kerala Lawacademy Law College in association with Center for Advanced Legal Studies and Research, KALSA. Man is a social animal. While we live in the society, it is important for us to know the opinion of the public. For this purpose, and as part of the 8th International Virtual Conference, we are organizing an audience poll. താങ്കൾക്ക് എപ്പോഴെങ്കിലും മതത്തിന്റെ പേരിൽ വിവേചനം നേരിടേണ്ടി വന്നിട്ടുണ്ടോ?
ഇല്ല, ഒരിക്കലും ഇല്ല.
ഉണ്ട്, വന്നിട്ടുണ്ട്.
വിവേചനം ഞാനത് പാർട്ടിയിൽ അങ്ങനെയുള്ളതൊന്നും ചേർന്നിട്ടില്ല.
ഒക്കെ അങ്ങനെയൊന്നും വന്നിട്ടില്ല. ഇല്ല ഇല്ല.
വിദേശത്തായിരുന്നപ്പോഴുണ്ട്, ഇവിടെ ആയിരുന്നപ്പോഴുണ്ട്.
പിന്നെ മതങ്ങൾ തമ്മിൽ എന്താ വ്യത്യാസം?
ഇല്ല ഇല്ല. നേരത്തെ ചോദിച്ചാൽ മതി.
എനിക്ക് താല്പര്യമില്ല.
ബോറാണ്. നമ്മുടെ ഇവിടെ തന്നെ എല്ലാ ജനങ്ങളുടെ ഇടയിലും ഉണ്ട്. ഇതുവരെയ്ക്കും ഉണ്ടായിട്ടില്ല.
ഇല്ല, എനിക്ക് അനുഭവപ്പെട്ടിട്ടില്ല.
മതവും ഭരണവും ഇടകലർന്ന് പ്രവർത്തിക്കുന്നതിനെ പറ്റി എന്താണ് അഭിപ്രായം?
റിലീജിയസ് ആയ ആൾക്കാർക്ക് അവരുടെ റിലീജിയസ് സെന്റിമെന്റ്സ് അല്ലേ വലുത്?
ഇല്ല
ഇല്ല
ഇല്ല,
ശരിയല്ല.
വേണ്ട,
നമുക്ക് അതിനോട് യാതൊരു യോജിപ്പില്ല.
ഇത് രണ്ടും മനുഷ്യനെ ഉപദ്രവിക്കുന്ന സാധനങ്ങളാണ്.
മതം സ്ത്രീകൾക്കെതിരെയുള്ള വിവേചനത്തെ പ്രോത്സാഹിപ്പിക്കുന്നുണ്ടോ?
ഇല്ലെന്നാണ്
മലത്തിൽ പറയത്.
എല്ലാരും ഒരുപോലെയല്ലേ?
ഇല്ല ഇല്ല. സ്ത്രീ സംരക്ഷണം ഒന്നാണല്ലോ ഉദ്ദേശിക്കുന്നത്.
അങ്ങനെയൊന്നുമില്ല. ഏകീകൃത സിവിൽ കോഡ് പ്രാബല്യത്തിൽ കൊണ്ടുവരണം.
നല്ല സാമൂഹ്യ നീതി ജനങ്ങൾക്ക് ലഭിക്കുകയുള്ളൂ.
അതിനെപ്പറ്റി എനിക്കൊന്നും പറയില്ല.
അപ്പോൾ സെക്യുലറിസമായിട്ട് കോൺഫ്ലിക്റ്റ് ആവുമ്പോൾ മൊത്തത്തിലത് ഇഷ്യൂ ആവും.
മതമെന്ന് പറഞ്ഞാൽ ഇപ്പോൾ ഏകീകൃത സിവിൽ കോഡൊക്കെ വരുന്നതിൻ്റെ ഭാഗമായിട്ട് ഇപ്പോൾ നിയമങ്ങൾ മാറുമെന്നാണ് എൻ്റെ ഒരു വിശ്വാസം.
സ്കൂളുകളിലെ പ്രഭാത പ്രാർത്ഥന തിരഞ്ഞെടുക്കാൻ കുട്ടികളെ അനുവദിക്കാമോ? അനുവദിക്കണം എന്നാണ്.
അതിന് ഒരു തെറ്റുമില്ല.
അത്യാവശ്യമല്ലേ, മൊറാലിറ്റിക്ക് നല്ലതാണ്.
നല്ലതായിരിക്കും എന്ന് എനിക്ക് തോന്നുന്നു.
അത് വേണ്ട, മതേതരത്വമല്ലേ നമ്മുടെ രാജ്യം.
മതസ്വാതന്ത്ര്യം പരമമാണോ?
എല്ലാം കൂടെ ഇടകലർന്നാൽ നടക്കില്ല.
തന്നെയാണ് അത് ഫണ്ടമെന്റൽ റൈറ്റ്സിന്റെ അകത്ത് അത് ഉൾപ്പെടുത്തിയിട്ടുള്ളത്.
മതസ്വാതന്ത്ര്യം, സെക്യുലറിസം എന്ന് പറയുന്നത് അതാണല്ലോ.
That has indeed shown light into the general opinion of the public. Though each replay showcases different understandings and background, the epitome that we can derive is that people of India stand for democratic secularism. I extend my heartfelt thanks to Anaka for her valuable effort and contribution in collecting the audience poll. Thank you so much, Anaka. Leaders instill in their people a hope for success and a belief in themselves. Positive leaders empower people to accomplish their goals. This statement is indeed true for us. We have Advocate Nagaraj Narayanan Sir, Director, Kerala Academy Law College, Member, Bar Council of Kerala, Special Government Leader, Forest, High Court of Kerala, and Adjunct Professor Nuals Kochi. Today, we are all united here because of his effort, vision, and support. From the bottom of my heart, I invite Advocate Nagaraj Narayanan sir to officially welcome our guest into this inaugural session. Sir, please.
Respected dignitaries on the virtual dais and other dignitaries of the virtual dais, and dear friends, brothers and sisters. Now, my duty is only to welcome the guest, so I should not be taking much time to take away their time, because all of you would be waiting to hear words of wisdom and the tremendous amount of knowledge they want to share on this subject. But I may just add just one word, because I've just heard somebody saying that about the opinion poll saying about the Uniform Civil Code. Now, Uniform Civil Code has been one issue that has been confronting us. That is to have a same law relating to family, divorce, marriage, divorce, maintenance, the rights of women, whether we should have the same law. Presently in India, we are having different laws. Maybe from Sri Lanka, Madam would be knowing the Indian position is that we are having different laws. And for Muslims, one law, for Christians, another law. It's all based on religious basis. So it is religious-based laws which we are having at present, whether it's Hindu law or Muslim. So one major obstacle has been the Muslim community, especially the large section of the Muslim community, and what we call as the secular group of the country, including the communist movement, have always been opposed the Uniform Civil Code, if it is implemented in a unilateral way, to bypass the rights of the minority communities. That has been one reason. And one major objection was, as I said, I repeat, it was from the majority Muslim community. But yesterday, there is a sign of hope, wherein only yesterday it has been reported that two eminent judges of the Kerala High Court, both, I should not say that, I should not take by religion, but I say that Justice Muhammad Mustaq and Justice Dr. Kausar Edapagat, both are Muslims. They have delivered a judgment saying that we should have the same law, irrespective of all religious considerations, for protecting women, for protecting human rights, for maintenance, adoption, marriage, divorce. You cannot have religious discrimination. You should have same law for all. It's a very welcome sign, and I'm very happy that he is one of the best judges, Justice Mustaq. And he's very young. He has a lot of years to go, and 100% sure bet for being elevated to the Supreme Court. So I'm very happy that a person who is going to be elevated from the Kerala High Court to the Supreme Court, Justice Mustaq, has delivered such a beautiful judgment. He was my friend during the days of my practice. I had the great opportunity of practicing fighting cases or having cases, dealing cases with him as my learned friend. I'm very happy to say this. And I only want to just add that religious freedom, religious fundamentalism, and religious extremism are different. And maybe I also want a space as an atheist. I would say I also want my space among all these people fighting for their religious freedoms. That is always with this these words, maybe some lengthy words which I had. Let me proceed to my duty of introducing and welcoming the guest for today's function. We have a very eminent galaxy of dignitaries, eminent dignitaries. The first dignitary I wish to welcome is our own man, I would say Dr. N.K. Jeeva sir, who is part and parcel of this institution. He was there, this institution has completed 55 years. He was right there, last 55 years he was there with this institution. He knows its development right from the inception. He is a member of the managing committee, the top managing committee of the institution, which is the Executive Council. And we are very happy about that sir had gone to, Dr. N.K. Jomar sir had gone to various other, he has taken up many other assignments, and now he's back fully with us. And he is such an eminent jurist that he was the head of the Department of Law in Kerala University, then Secretary of Legislative Assembly, which is a post which is held by district judges and high court judges who have become high court judges. Then he had also held the post of legal advisor to the Chief Minister of the state. Apart from all this, he was the Vice Chancellor, former Vice Chancellor of the National Law University in Kochi, NUALS, National University of Advanced Legal Studies in Kochi, which is the Kerala's only national law university. And it is during his period that the present campus you can find in the website all has been developed. He has contributed a lot to that. And he is a visiting professor in many foreign universities, has so many academic contacts outside India, a friend of so many eminent professors abroad from the foreign universities. And we are very fortunate, though he is part and parcel of our institution. For the sake of formality, I have to extend a very warm welcome to Dr. N.K. Jomar sir. Welcome, sir, to this function, sir. Thank you, sir. Next, I have to say welcome to Professor Jeeva Nirella. No, I'm not sure whether I'm pronouncing it correctly. Professor Jeeva is Deshabandhu Professor, is of the Faculty of Law, University of Colombo, one of the most famous faculties in the country, in the nation of Sri Lanka, and the capital city of Colombo, University of Colombo, Faculty of Law. And she has started a career in 1993 as a lecturer, so much senior to me, I hope, because I started my practice only in 1993. So she has started her academic career way back in 1993. And she's holding so many important positions in her country, Sri Lanka, our immediate neighbor. And she was a member of the first board of management of the National Authority for Protection of Victims of Crimes and Witnesses from 1916 to 2018. She was the first female director of the board, and she was appointed as the first female director of the Colombo Stock Exchange, Sri Lanka, from 2012 to 2019. She has so much of contributions to the academic field. For the last 15 years, she has published so many books which are published by the most reputed publishers like LexNexis and other Springler, Routledge, Trailer, and all these world famous publications have carried her publications. And she's also the member of the executive committee and Constitutional Council of World Center for Human Studies, and the Presidium of General Assembly of Asian Criminology Society, as the first Sri Lankan who has been appointed to the board of the this Asian Criminology Society. She has received the title of Deshabandhu National Award Honor conferred by the Democratic Socialist Republic of Sri Lanka at the Ceremony of National Honors of 2019, which is to recognize the distinguished service of national meritorious nature, of service of national importance and meritorious service to the nation. And we are very fortunate that we are having Professor Jeeva to inaugurate this session. Very eminent person. And I would say, after inaugurating, and please, we always want your association with our institution. Our institution will be much blessed, will go to heights with your association, because it is such a impressive profile at the global level, madam. So we are very happy that you are here, fortunate that you are. On behalf of all those present here, Law Academy extends you, madam, a very warm welcome to this function to deliver the inaugurals. Thank you, madam. Welcome, madam. Then Dr. Surya Prakash, S. Surya Prakash sir is here. He is a known figure in the Indian academic circle. He is presently the Vice Chancellor of Damodaran Sanjeevayya National Law University, Visakhapatnam, which is in Andhra. Now, before that, he served as Vice Chancellor of the Maharashtra National Law University, Aurangabad, Maharashtra. And before that, he was the Professor of Law at the National Law Institute University, Bhopal, Madhya Pradesh. All are premier and the top universities in our country, and he has such a rich academic experience. So many, I'm not going to deliver on, and if you all wait to listen to their speeches, because he has so many credits to his academic this, because saying that he was the vice chancellor of 2 universities, also before that, that itself serves so many academic contributions for law reform, for social change, and so many books and articles. So we are very happy, fortunate, privileged that you are here to deliver a keynote address in the inaugural session. On behalf of all those present here, I extend to you, sir, on behalf of the Kerala Law Academy, a very warm welcome to this function. Welcome, sir. And another important personality is who is another eminent personality is Professor Dr. S.P. Singh. He was a professor. He is presently the professor of social sciences and dean of social sciences and humanities, holding the chair of professor in the Chanakya National Law University Law School, Patna, another reputed university in India, National Law University. He has been a resource person, giving training to various sectors, and a resource person for the University Grants Commission, the academic circle. He has contributed so much of research articles and books, and he has so much of international exposure and experience. Visited so many countries in Europe, including Germany, Netherlands, Poland, Italy, for academic exchanges, academic as resource persons. And he was United Kingdom Thames Valley University has always been having his association as a research person. So such an excellent, eminent personality in the legal field, academician par excellence. Sir, we are very happy, sir, that you are here with us to deliver a keynote address in along with the Vice Chancellor of the National Law University, Visakhapatnam. Sir, on behalf of the Law Academy, it is my privilege to welcome you, sir, to this function. Welcome, sir. Welcome, sir. Now we have Professor Dr. Y.F. Jayakumar. Sir has already associated so many times with our institution. He is known to most of our academic community here. He is presently the Dean of the Research Council of the Maharashtra National Law University, Aurangabad. And he was earlier, he had served as a Dean of Faculty of Law, Osmania University, Satvahana University. And then prior to that, he had also served a small term in the Pendekandi Law College, Hyderabad, as the principal, then Dean of so many universities, life member of the Indian Institute of Constitution and Parliamentary Studies, and a member of the Governing Council of the Premier Research Institute, Indian Law Institute. He has written so many books, contributed so many research articles and books, and some of which are of great interest for me because it relates to climate change and environmental law. And it's also my subject. And consumer area, human rights, and new challenges. These are another area which he has done. So many PhDs. He has produced 20 doctorates in law. That's a great achievement, sir. And others also have such achievements too. They credit. So another eminent dignitary among us. So we are very happy, privileged, and proud that you are here, sir. Professor Dr. Y.F. Jayakumar, sir, to be here to deliver our special address with your experience of 30 years of teaching in the academic field and contributions in the academic field. On behalf of the Law Academy, sir, I extend to you, sir, a very warm welcome. Welcome, sir. And now, though all are part of our faculty and team, but still for the sake of formality, I should extend a warm welcome to our principal, Professor Hari, sir, who is always with the students and faculty, always. Harindra, sir, welcome, sir. Then K. Anil Kumar, sir. He is a very important personality as far as our institution is now concerned. The institution is making strides, climbing steps only because of him, because he is such a visionary. He has so many ideas. Sir, K. Anil Kumar, sir, please welcome, sir. And then Professor K. Anil Kumar, sir, welcome, sir. Then I also welcome another Professor G. Anil Kumar, then Assistant Professor Arun V. Unitan, then Dr. Dakshina Saraswati, Srimati Radhika, Assistant Professor, Advocate Arya Sunil Paul, Assistant Professor. These are the Assistant Professors who have been running after this for organizing this wonderful program here. And I also extend all other faculty members and non-faculty members, and also welcome the student conveners, Rishikesh, Shruti, Darshana, Ashik, Nandakishore, Arjun, Sri Durga, Gobiga, Abhirami, Anandu, then the PG student conveners who are Advocate Mahesh Subramania here, Advocate Smita, Advocate Anup Krishna BS, Advocate Prida, Advocate Dilip H. All these are part and parcel of our institution. They need no introduction. They need, for our students and others, they need no welcome, but the sake for formalities. I extend a warm welcome to all the faculty members, student conveners, PG conveners, and all the participants, because participants, we have 65 plus research paper publications which have been selected for this. And it's a wonderful, because so many research papers have come, but 65 papers are being presented. I hope this will come out with better ideas and it will contribute to society. And with that hope, I welcome all the participants and all those who are present for today's function in this virtual platform. So welcome all, and thank you for bearing with me for so long. Thank you. Thank you very much.
Thank you, sir, for your warm welcome. I take this opportunity to welcome you too into the ceremony, sir. Today, we are blessed with the presence of Dr. N.K. Jayakumar, former Vice Chancellor, NUALS, Kochi, and member, Executive Committee, Kerala Lawacademy Law College. He is a recipient of Manatha Krishna Menon Medal, Bar Council of Kerala 1975, and Justice K. Nair Gold Medal, University of Kerala 1973. It is an honor and privilege to have such a distinguished personality on this occasion. I invite Dr. N.K. Jayakumar, sir, to give the presidential address to this function. Sir, please.
Professor Jeeva Nirella will inaugurate this conference. Except Professor Jeeva, all other resource persons are my close friends. Professor Surya Prakash, Professor S.P. Singh, Professor Y.F. Jayakumar, Principal of the Kerala Lawacademy Law College, Professor Harindran, the organizing team headed by Nagaraj Narayan, Dr. Dakshina, Arun P. Unnita, G.S. Gokul, and there are a lot of others. If I start mentioning the names, it will take a long time. Faculty of the Law Academy, students, researchers, other friends and well-wishers. At the outset, let me congratulate the Kerala Law Academy and the Center for Advanced Legal Studies and Research for taking the initiative in organizing this conference on a theme which has great contemporary relevance. Unfortunately, I did not have the opportunity to go through the abstracts of papers to be presented at the seminar. Therefore, I don't have a clear picture of the various topics that may be covered in the technical sessions. Therefore, I think it is appropriate for me to confine my observations to a few general issues. I will try to flag a few basic questions which are very relevant to the topic that we are discussing today. Maybe you all know that the freedom of religion has two dimensions. One is, we may call it the internal dimension. The exercise of religion and freedom to believe. It is a question of my own conscience. I may also choose not to believe in any religion. That's also included in my freedom. Apart from this internal element, there's an external aspect of freedom of religion, which occurs in the public domain. It is the freedom to act on one's beliefs It's not just belief, but also the contact, expressive contact, exercise of the freedom. This freedom has remained at the very core of the matrix of fundamental human rights and freedoms. Therefore, the title of the conference appears to be very appropriate. Human rights is also linked to religious freedom, as it should be. Naturally, we find emphatic assertions of the right to freedom of religion in human rights, basic human rights documents, including the Universal Declaration of Human Rights, International Covenant on Civil and Political Rights. I will come to that. Taking the cue from the international human rights documents, many national constitutions, including the Constitution of India, have incorporated the right to freedom of religion in the Constitution. It is also pertinent to remember that religious freedom is an increasingly contested and divisive issue in national and international politics and law. There's political dimensions as well. We can never meaningfully discuss freedom of religion or secularism if we divorce it from the domain of politics. In the legal discourse, two predominant features are conspicuous. One is the conception of political authority as secular and neutral. We know there was a time when church and state were rather fused together, blended together. There was no separation between church and state. Religion exercised a great influence on the decisions of the state, the governance, all the issues. So the bifurcation of the state from religion, division of the state and church, this is one of the prominent aspects of the concept of religious freedom and secularism that we have adopted. Political authority remaining secular and neutral. Neutrality for the political authority. Second is the conception of the right in terms of individual freedom. So that individual dimension, as an individual right, as an individual freedom, right to freedom of religion has to be protected. It must receive the protection of law. Now, how do we protect a right by law? Our strategies are, well known. State intervention is taking place through legislation as well as judicial. Executive is there for the implementation of the law enacted by the legislature, and also for enforcement of judicial decisions. What happens as a consequence of legal intervention, either through legislature or judiciary, is that many questions which are essentially social, political, or internal to religion are transformed into legal or constitutional issues and passed on to the courts for adjudication. The welcome address, Nagaraj was mentioning about a very recent judgment of Kerala High Court delivered yesterday, pointing out the need for a uniform civil code. This is precisely the question what I want to pose. Is the judiciary competent to pronounce on such issues? In many areas of religious freedom, we usually pass on the decision to the courts, whether it is Rama Janmabhoomi or entry of women into Shabarimala temple, ultimately it becomes a question for the judiciary to decide. But the judiciary, with all respect to the judiciary, I must say that the competence of the judiciary is questionable. These are issues which are very complex, intertwined with dimensions which are social, cultural, political, religious, which has to be tackled with great sensitivity, great care, great caution. Otherwise, there will be fragmentation, conflict, chaos. Transferring major issues to the courts or the legal system is also dangerous from the human rights point of view. I remember Justice Tanaka, a judge from South Africa who was elevated to the International Court of Justice, once made a very remarkable observation. He said, we want all our human rights to be elevated to the status of fundamental rights. Well and good. But what happens when they are elevated to the status of fundamental rights or constitutional rights? The state, whether through the legislature or the judiciary, gets a power, acquires a power to modify the right, to define the right, to suspend the right, to abridge the right, to take away the right. If they remain as human rights, this is not going to happen. Human rights cannot be taken away by anybody. Human rights cannot be suspended by anybody. The famous judgment of Khanna, Justice Khanna in ADM Jabalpur case, which is popularly known as the habeas corpus case, is a shining example of how a human right, a natural right, remains intact, must remain intact, even during an emergency when all fundamental rights can be suspended by the government. Similar is the situation with freedom of religion. When that freedom is elevated to the status of fundamental right, then it is for the state, organs of state, whether it be the judiciary or the legislature, to define the contours, to give a precise content to the concept of freedom of religion. That is one point which I want to emphasize at the very beginning of this conference. Secondly, I would refer to an observation by Professor Mark Gallenter. Many of you must have heard about him. An American professor who has done extensive research on Indian constitution and especially social justice. His most well-known work, published under the title Competing Equalities, deals with the reservation issue in India. Speaking on freedom of religion, Mark Gallenter observed, through laws, certain aspects of what is claimed to be religious are given recognition, support, and encouragement. Certain aspects of what is claimed to be religious are given recognition, support, and encouragement. Others are the subject of indifference. Finally, some are curtailed and proscribed. So he makes a division, a categorization. There are so many things which we consider as religious subjectively. Some of these are recognized by the state, supported by the state, encouraged by the state. To some of our religious beliefs or even practices, state may be indifferent. There are some which are curtailed, proscribed. For example, human sacrifice was there. Even animal sacrifice has been prohibited at a later stage. Sati was prohibited at a later stage. So, state acting in response to the changing nature of society, changing needs of society, social reformation. So that is what we are seeing. So uniform civil code again may be an area where the state has to take a decision. State has to take a deliberate decision whether to remain indifferent to that or whether to support, encourage, and legalize the civil code. Now, we all know that Article 25 of the Indian Constitution contains freedom of religion. It guarantees freedom of conscience, right freely to profess, practice, and propagate religion. A power is conferred on the state to impose reasonable restrictions on the grounds of public order, morality, health. Making of laws, providing for social welfare and reform, regulating or restricting any economic, financial, political, or other secular activity which may be associated with a religious practice. This is the literal content of Article 25. But as you could easily see, many vague expressions, indeterminate usages, which do not have a precise meaning, but which can attain a meaning depending on the socio-economic, cultural conditions in society and interpretations from time to time. What do you mean by morality? Reasonable restrictions on the grounds of morality can be imposed, but what exactly is the meaning of morality? The relation between law and morality is a very complicated subject. The meaning of morality is more complicated. Similarly, laws providing for social welfare and reform may go against the initial guarantee of freedom of conscience and right free to profess, practice, and propagate religion. These may be curtailed by a law providing for social welfare and reform. What does it mean? What someone considers as a measure of social welfare may be considered by me as antisocial. Yes. So these are all matters which are subject to interpretation, changing, varying approaches. And similarly, a very important question arises on what happens when this fundamental right guaranteed in Article 25 is in conflict with other fundamental rights. Which should prevail, which has to prevail, which has to override which. That question also assumes significance. And another word in Article 25 which has become very controversial, provoked much debate, is the word propagate. What do you mean by propagate? When I have the right to propagate my religion, naturally implies that I have the right to influence others. My religion is better than other religions. So, why don't you abandon your present religion and join my religion? This is the best. Or, it does not include such a right. The right to convert another person to one's own religion. Is that right embodied in the right to propagate religion? This is a burning issue even today. Many states in India, even during the colonial period, in the 1930s, you find many provinces in India enacting anti-conversion laws, which restrict, sometimes prohibit the right to change one's religion. If I don't have the right to change my religion, the entire guarantee of freedom of religion becomes irrelevant. So that right nobody can take away. That is my conscience, my belief, which is guaranteed without any restriction. But problems arise when I try to convert another person to my belief, my religion. Today, in many states in India, laws imposing restrictions on converting a person to another religion are in existence, and they are euphemistically called Freedom of Religion Act. The effect of these laws is to restrict curtail freedom of religion, but I don't know why. They are called Freedom of Religion Acts. I don't want to go into the details because detailed technical sessions are coming and you will discuss threadbare the ramifications of this religious conversion. The question that arises is, all these so-called freedom of religion laws, which in effect, in practice, restrict the right to change one's religion or the right to persuade another person to convert to another religion. The words used in the statutes are conversion by allurement, alluring a person, tempting a person, or by threat, by force, by fraud. These are all prohibited. And here again, we find that there's a stereotype being perpetuated, a presumption being encouraged. What's that presumption? The presumption is the so-called weaker sections in India, the scheduled castes, scheduled tribes, backward communities, women. These sections are vulnerable to pressure. They are easily susceptible to influence. They are easily lured by promises, false promises, offers. They are very easily threatened by evil consequences. So it is on this basis that anti-conversion laws are enacted. So that is something I feel you have to discuss in the technical sessions. As far as human rights are concerned, the Universal Declaration of Human Rights as well as International Covenant on Civil and Political Rights accept, recognize the freedom to change one's religion or belief, the freedom to adopt a religion or belief of his choice. It is treated as a non-derogable right. A non-derogable right cannot be taken away, whatever be the situation. Even in an emergency where all other rights may be restricted or taken away, this right must remain intact because it is described as a non-derogable right. Today, these anti-conversion laws are again being debated. They have come to the limelight. Because there's an orchestrated attempt. Not because conversion is such a big problem in India. It's never been statistically proved that large-scale conversions take place. So some people have a vested interest in projecting religious conversion as a very burning issue, threatening the social fabric. Is that really so? I doubt. So, the importance being given to anti-conversion laws the political agenda behind that move is suspicious. Now, secularism is another concept which you have to discuss along with freedom of religion. India has all along been a secular nation. And in the Constituent Assembly, there was a demand that the word secularism must also find a place in the preamble. Unfortunately, that was not accepted at that time. But later on, in the year 1976, through an amendment, secularism was added to the preamble of the Constitution. But people have their doubts. What does secularism mean? Each person advances his own pet notion of secularism. But a few things are very clear. Secularism definitely means the separation between religion and state. Secularism definitely means the state considering all religions equally, with equal respect, equal consideration. Secularism clearly means that religious denominations, irrespective of their numbers, must receive, they must be able to enjoy the full protection of the guarantee of religious freedom. Numerically, you may be a minuscule minority. But the right of the minuscule minority to serve their culture, their religion, their customs is as important as protecting the rights of the majority community, which may consist of 80% or more of the population. So your followers may be just 1% of the population, but even less than that. But that doesn't disentitle you to the protection of the guarantee of religious freedom. As far as looking at it from the purely legal angle, you know that secularism has been considered as a part of the basic structure of the Constitution in Keshavananda Bharati and reiterated in S.R. Bomai. When secularism is being elevated to the status of an integral part of basic structure, it necessarily means that even by an amendment, the concept of secularism cannot be diluted, shall not be diluted. So from the judiciary's part, secularism has received a very strong support. And it is also important to understand the connection between secularism, equality, and democracy. Without equality, there cannot be any democracy. Without democracy, there cannot be any secularism. These are so integrally interconnected that we can never think of one without the other. So secularism, equality, and democracy are the three core concepts on which our entire constitutional edifice is built up. So we cannot make any compromises on these three basic values. We have to preserve secularism. We have to uphold secularism. Along with that, we must always uphold equality. With these two values, democracy will remain healthy, vibrant. There's no doubt about that. So the young scholars who are discussing various aspects of freedom of religion from a human rights angle I'm sure they will devote some attention to some of the points which I have flagged in my presidential speech now. I don't want to take more of your time. I thank each and everyone for a patient listening. Thank you again, Kerala Law Academy, for giving me this opportunity, and I am sure that the Law Academy will continue to take more and more initiatives in the academic field so that its relevance, its presence, not only in Kerala, but all over India and even abroad, will be further strengthened. Thank you.
Thank you, sir, for your valuable words. We are truly enlightened. Now, we have the presence of an eminent personality, Professor Jeeva Nirella, Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka. She has an exceptional knowledge in various dimensions of law. I welcome Professor Jeeva Nirella for the inaugural address. Ma'am, please.
Thank you. And very good morning to you all. So, Dr. Professor N.K. Jayakumar, former Vice Chancellor of the Kochi University, and my dear friend, Vice Chancellor Professor Surya Prakash, Vice Chancellor from Damodaram Sanjeeviya National University, and all the other dignitaries who are presenting here to share some of the very sensitive and to say crucial and very important the topic in this conference. So at the outset, I wish to extend my sincere gratitude to the organizing committee for inviting me to deliver the inaugural speech at this 8th International Conference conducted by Kerala Academy, Trivandrum. And under the very current topic, recent trends in human rights and changing facets of religious freedom. As the former Vice Chancellor, the presidential speech given, he also agreed to the point that it is very important and contemporary relevant topic. I should add here to say that it should be discussed at the international, regional, and domestic level. My dear friends and all the participants, I must say that, as I said, it is a very sensitive area. If we say something, people may get hurt, thinking that we are accusing them, we are insulting their faiths and beliefs. Therefore, I thought that without, hurting any of the feelings, or let's say that single feeling of any of the person, to give my inaugural speech. And therefore, I thought that the best way of delivering my inaugural speech, pointing you the measures that have taken by the international community in relation to the protection of religious freedom, whether we have different opinions, criticisms, and all sometimes advocates for that, as well as taking my country, Sri Lanka, what Sri Lanka has done in promotion with this religious freedom. Because I think India and Sri Lanka and many of the Asian countries, as well as all the other countries, it's now we can't say that we have only one particular ethnicity and it is limited to only one particular religion. Today, I see that the whole globe as the pluralistic society. We all have the different faiths, the different religions, different beliefs, and we belong to different ethnicities, so on and so forth. Therefore, I thought that it is better to deliver something relating to the international standards which are talking about the human rights aspect of this religious freedom and the situation of Sri Lanka. So my dear friend, freedom of thought, conscious, and religion or belief is one of the cornerstones of pluralism, and growing evidence indicates that respect for religious pluralism is indispensable to peace and security of the world. The protection of the rights to freedom of religion or belief enables people, all faith or none, to live together, learn from each other, and be treated equally. In other words, the right to freedom of religion is fundamental to me to peaceful and inclusive societies. However, as you all are aware, religious persecution, oppression, and discrimination, etc., worldwide continue to push all peace lovers to stand for the protection and promotion of religious freedom, because finally, if we have something, we are run to either to church or to the temple or to the mosque to asking, to protect or request something in the form of vow. Therefore, today, in my, as I said, that inaugural speech, I wish to discuss how the international society or the international community has taken the measures to develop this, as well as Sri Lanka. So let me to share with some statistics to have that I have obtained from e-literature, which is freely accessible. And therefore, you can see at the end of the year 2020, out of the total population of the world, that is 7.79 billion, Christians are dominating because they are having the majority. I don't know whether that word is really good to be used. That is 2.382 billion. As a percentage, it is 31.1111, where the Muslim community, who has the faith in Islam religion, we have the 24.9% out of the total population. And Hindus who believe in Hinduism, there are 1.161 billion, that is from the total population, it is 15.16. And Buddhism, 506 million, consist of 6.62%. So when I see that, when I went through these statistics, I saw that 15.58% out of the total population, they don't believe in any faith, right? So, but I'm a traditional person. I am a believer. I believe in my religion, but I do not hurt anybody, and I don't take the religion as a weapon to hurt anybody. I think that is what we all should expect from if the person who is really believing or really practice the teachings of the religions. So among the others, Buddhism, though it is considered as a religion, if we go by the contextual form, it's a philosophy. So all the others we can call religion because it has always either believe in God or any other beliefs. So let me to give some statistics relating to Sri Lanka, because many of our Indians and other countries, I think I am the only Sri Lankan who is participating in this conference. So the diverse social fabric of Sri Lanka is made up of different ethnicities, the religions, linguistic and cultural groups, which is similar to India. So as far as the religious demography of Sri Lanka is concerned, out of the total population of Sri Lanka, it is very small. The country is small, the population also small, relative to your country as well as China. that is concerned, our population is concerned, out of the total population that is approximately 21.5 million, the majority is Buddhist, and it is about 70% of the total population. And 13 is Hindu, 10% is Muslim, and 7% is Christian. So Buddhism is the religions practiced by majority of the country's Sinhala population. That is the larger population of Tamils is Hindu, and Muslims are adherent of Islam. And the Christianity followed by both Sinhala and Tamil community people. So, my dear friends, I wish to state here that love, kindness, and compassion are at the core of the teachings of all the religions. Those teachings direct the people to stay peacefully, respect each other, treat equally, and to stay without doing deliberate, pre-planned, systematic harm or discrimination to other people who belong to the other communities or believing other the faiths. However, the world bears witness to persistence of intolerance and discrimination based on religion or belief, and proliferation of violence in the name of religion, the manipulation of religion in the interest of political ideology are increasing tension between the religion and the state politics. It is not only to Sri Lanka, that is common to all over the world, as the previous speaker said. And he took the point that, the constitution and the pluralism and how this work within the concept of religious freedom. So religious extremism and engage in widespread antisocial activities in the name of the religion. Discrimination of women and children due to the practice of some beliefs posed to violate the other basic human rights of the people. Furthermore, rising of religious extremism affected on the security of the people, human development, and efforts toward the peace. Certainly, the promise of freedom of religion or belief for all remains as one of the most challenging and demanding human rights today. I hope that many of the presenters are coming with those issues to be tabled and deliberate and go for a robust recommendations in order to protect the religious freedom, or let's say that go for a sustainable peace. My dear friends, if we take once again Sri Lanka, while religion is closely tied to the ethnicity, ethno-religious identity is somewhat fluid between Sinhala and Tamil communities, whatever said and done by the world community. As a person who is representing Sri Lanka, I can say, since some people from both communities share common religion. Although religion had always played a crucial part in the country's post-independent identity politics, religion itself was not deemed as a direct cause for the armed conflict which continued for a long period of Sri Lanka, putting many people into a very desperate situation. We had undergone the 30 years of the war because of this. However, with the incident that taken place on 21st of April 2019, tension among the different communities has been developed, which is, I must say, very sad to state here. So my dear friends, since my approach is to consider the international, the standards which have been taken in order to protect the religious freedom as one of the human rights, I quickly just say that, what are the such standards? Because if I do not mention here at my inaugural the speech, I think that it is, I will actually run down the international communities that the significant effort. So we all are aware, And as the former Vice Chancellor, who was our first speaker, also said that the Universal Declaration of Human Rights bodily proclaimed to inherit the dignity and the equal rights of all members of the human family, guided by the vision of equality for all. The Declaration enshrines the fundamental rights of every human being for freedom of thought, conscience, and religion. The international community was unanimous on adoption of this declaration and its codification posed in adopting other subsequent instruments of international law that protect and promote the different rights of the people, including freedom of religion. So, Article 18 of the UDHR is the significant standard in relation to this religious freedom. So, also, I must emphasize here that the Universal Declaration, other than the Article 18, also affirms the right to freedom of association and non-discrimination that bear on laws affecting the structuring of religious communities. Thus, the UDHR recognizes right to freedom of peaceful assembly and association in its Article 20. According to the declaration, every individual is entitled to all the rights and freedoms set forth in this declaration without distinction of religion, as it is mentioned in Article 2. And all are equal before law and entitled without any discrimination to equal protection of law, as it is mentioned in Article 7. So ICCPR, a legally binding treaty, it is in Article 18, enshrines the substantive right of freedom of religion or belief, which was preserved in Article 18 in UDHR. So there, once again, with this legal binding, ICCPR also respect non-discrimination, freedom of association. However, it is very carefully designed, or I say that draft, to note the limitations of freedom of religion or belief. So, in addition to this, the two international instruments, give me one second. We are sharing the office, right? My husband and myself. I'm so sorry that if there is any disturbance happen because of that. So among the, other than the two instruments, international instruments, which I mentioned here, Declaration of Elimination of all forms of intolerance and of discrimination based on religion or belief in 1981 also recognizes the right to religious of freedom or freedom from discrimination based on religion and freedom of association. So therefore, I want to draw your kind attention, whatever said and done, the international community also respect to this. Why? Because not like the law, the religion actually comes from the faith as well as the social norms. Sometimes when we teach criminal law, we consider that which under morality. So therefore, if you're trying to touch these type of very sensitive norms, so then as a person, a peace lover, I think that we are running into an unnecessary problem. However, I now take the little time to just to show you kind attention, the regional, the efforts that have been by the different regions and to promote and protect the right to or freedom of religion. So there I would take only the European Convention on the Protection of Human Rights and Fundamental Freedom that adheres to the substantive right to religion's freedom by its Article 9 and freedom of association by its Article 11 and along with the other related provisions such as Article 6(1) and Article 13. Since I don't have that much of time to explain all the decisions, the landmark decisions with the facts and the decisions, I just would like to mention here a very important and landmark decisions that have been taken by the European Court in relation to the protection of religious freedom and the freedom of association. The first one is Copernicus versus Greece, that was decided in 1993. Larisis and others versus Greece, that is also once again decided in 1998. Balsamis versus Greece in 1996. Talax versus Turkey, 1997. Buscarini and others versus San Marino in 1999 are some of the cases discloses the authentic nature of the Article 9 of the ECHR. So therefore now it is not a mere the protection of right. It is, in the European Union, it is very firmly said that how to protect the religious freedom as well as freedom of association. So I would draw your kind attention on the European courts decided in 1998. There are two cases. The first one is United Communist Party of Turkey versus Turkey and Disoporos and others versus Greece, where once again freedom of association that have significantly implications for the law of religious association with the country. So my dear friends, so this is therefore I would say that yes, at the international level, subject to many criticisms and support, that means for and against, yes, the international community and the regional communities, even that American, the Human Rights Protection, the Convention, as well as the African one, they are also considering this, the religious, the freedom, especially the right to association. So I now, as the second part of my short speech, I would like to draw your attention. What is the situation of Sri Lanka? My dear friends, Sri Lanka also a member country to the United Nations, as well as to the signatory to the several international treaties to recognize freedom of religion, including Universal Declaration and ICCPR. So Sri Lanka has a sufficient constitutional and legal framework to protect religious freedom. The constitutional provisions that are directly associated with religion and religious freedom are Article 9, Article 10, Article 12, and Article 14(1)(e). So however, with regard to Article 10, there is a small issue because it accepts that, the Buddhism should be the main religion respected by the Constitution. However, the same Constitution in its other articles, it is very clearly mentioned that all the other religions are also equally treated. Therefore, I don't think that this the two taking into consideration only one particular provision to criticize the Constitution of Sri Lanka to create unnecessary problems, where we have to take the Constitution, a holistic approach to consider the freedom of religion as well as the human rights. Why I say, as you're in your Constitution, the Constitution of Sri Lanka also in the preamble, it says that, so this, the Constitution is enacted to ensure the freedom, the equality, justice, fundamental rights of the people, and in addition to that, there is another one, independence of the judiciary. So if you take the equality principle, if it is the one of the main, the key point of our Constitution, so we don't have any room to take one particular provision to see that the the Sri Lankan, to say that the Sri Lankan constitution is differently treated to different communities and the religions. So I would like to just mention here one of the very landmark or the important case where the religious freedom and the freedom of association has been taken into consideration. That is Premalal versus Veerasuriya. For your the benefit, I would like to mention the reference number also here. That is 1985 2 SLR, page 177. It is freely available. If anyone, you can go through and see how the Sri Lankan judiciary respect to these two the rights. So then next I want to show you that under the blessings of this the Constitution, though we have 18th the amendment, the 19th amendment, now we have the 20th amendment, whatever it is, I mean the main Constitution, it respects all the religions without any discrimination. That is my point of view in relation to the Constitution of Sri Lanka. So in Sri Lanka's legal system, it includes laws that protect religious freedom in the country. So very recently, in the 20th century, if I mean, that is the correct way to say that, International Covenant on Civil and Political Rights Act number 56 of 2007, that is the section 3.1 states that no person shall propagate war or advocate national, racial or religious hatred that constitutes incitement or discrimination, hostility or violence. And as section 3.2 states that aiding, abetting, attempting and threatening to commit such an act is a criminal offense. So this criminal offense is an indictable offense. I think the most Indians know that it goes to only to the High Court for trial, and non-bailable and cognizable offense. And the prescribed punishment is 10 years imprisonment. This is how the Sri Lankan, the legal system is trying to protect the rights of the freedom of religion. So in addition to that, I must say here that the penal code also took the effect, not today, long before, that is in 1880s, right, to protect the religious freedom by criminalizing to all type of the actions, the behaviors, omissions, and the speeches, which is, included some sort of the hostile manner as well as the damages done to the religions. There are section 209, injuries to defiling a place of worship with intent to insult the religion or any class. 290B, acts in relation to places of worship with intent to insult the religions of any class. And 291A, 291B, all are referring to the protection of the rights of the freedom of religion, while criminalizing doing any sort of harm to any of the religion. So however, and if you take the civil aspect, we have the special laws in Sri Lanka have the special focus on, as our director sir said, to protect or to discuss about the marriage, divorce, maintenance, the succession, with specifically focus on the religions. One example is Muslim Marriage and Divorce Act. So there we once again respect whatever said and done, even to the child marriages which are recognized by the Muslim community based on their the religion. However, very recently, now we are doing, with the consultation of all the religious leaders, right, to come to a concrete solution, that to adhere to the definition of the child, which is to consider any human being who is below 18 should be considered as a child. They are eventually, the child marriage would be slowly removed without, hurting any of the person. So other than that, this type of the legal mechanisms, Sri Lanka, there are some social institutions that the activists or that the social, the institutions also took a lot of and the several steps to protect the religious freedom, considering that as a fundamental human right cannot be derogated at any cost. I just very simply, very quickly mention one of one of them. They are Sarvodaya National Peace Council, Sarvodaya Shanti Sena, Center for Peace Building and Reconciliation with the participation of religious leaders from all four main religions, Muslim Aid, Interreligious Council Sri Lanka, Center for Peace Building and Reconciliation, National Peace Council's District Interreligious Peace Committees, and there are many more, but I would like to stop here. That is to encourage, promote, and protect the legal harmony of the different communities or the communities, the people who are believing the different faith. So, my dear friends, I'm very fortunate to be a person, to serve on the board, which is known as Office for the National Unity and Reconciliation, which has been established in 2014 under the Gazette issued by Government of Sri Lanka. I am a member of that board, and we are also trying to do a lot of things, to promote the religious harmony as well as the good understanding of the different ethnicities in Sri Lanka. There are 7 programs that we are, running. We actually run 7 programs. There, what we are trying to do is calling the religious leaders, the people who are engaged in educational, the sector, the private sector, the public sector, as well as the children, to show them the importance of having the different or the diversity of the differences of the people, saying that if we have the different, the people who belong to different ethnicities, who believe the different, the religions, this is the beauty of the human nature. And if you say that if you go to a flower garden, if you have only one kind of flower, you can see that it is sometimes you may little bored, but whereas you have lot of the different colors of flowers give different fragrance. So that is the beauty of that, the particular flower garden. So therefore, we try our best to consider taking that this diversity for the unity of Sri Lanka, considering the beautiful nature of the diversity of the different the religions which are teaching finally the final truth to me, that is peace, love, understanding, and compassion. So therefore, I would like to say, before I concluding my the inaugural speech, I was a little bit careful to use the wordings, to find the wordings also to speak at this international conference rather than putting my the words, right? Whatever we said and done, whether we have that, different opinions and different perceptions relating to following the religion or the beliefs, so then the international community also has recognized that. Because under morality, that is one aspect we are considering the religion. And if the international community recognizes that, because it is the universal though it is a soft law, universal law for everybody. Therefore, each and every, the domestic, the jurisdictions also, in their constitutions or their main legal the documents, try to respect the right to freedom of religion, including the freedom of association, Therefore, ladies and gentlemen, my perception towards this right to religion of freedom is not a mere legal right, but also be a duty of the people which come from the understanding and respect of other people and their beliefs, and tolerate the other people. Here, what is obvious is that all interfaith peace-building efforts originate from the understanding that all religions espouses universal spiritual truth and ethical values, not unique to any particular religion per se. That is my personal view. This is the message that all the religious leaders and those who are strongly believe in values of their religions, as well as the primary, the secondary, the tertiary educational institutions strive to communicate to adherents with their own religions, as well as the other, as well as those from other religions. Therefore, while recognizing there are some loopholes, as the previous speaker pointed out, in relation to some of the definitions, even in the international the standards, we must set up a robust platform where, while recognizing the freedom of religion as a human right, and to promote that and to protect that, while living with others with the understanding and the tolerance of the other people's faith. Therefore, I appreciate this effort taken by the Kerala Academy for giving us the opportunity to listen to the latest research findings of researchers and providing those researchers a platform to submit their research findings and forum to deliberate on this subject. Yes, we can include the constructive criticisms, the dissents, the advocates, so on and so forth. That is what the main objective of any international or national conference is. Therefore, while congratulating all, and I wish you to successful of this event. Therefore, finally, I would say, God bless you. May Triple Gem bless you. And Assalamu Alaikum. Thank you very much.
Thank you so much, ma'am, for your valuable time and words of wisdom. Now, we have Professor Dr. S. Surya Prakash, Vice Chancellor, Damodaram Sanjay National University, Visakhapatnam. He is a prolific writer and academician with over 25 years of experience. I welcome Professor Dr. S. Surya Prakash for the keynote address. Sir, please.
Thank you, Gokul. I think I am audible.
Yes, sir, you're audible.
Okay. Thank you, Gokul, and thank you for the kind invitation extended to me by the Kerala Law Academy. And in fact, in our university, we are conducting an international conference right now. It started yesterday. It is on vaccine parity, vaccine equity, and there are so many international guests are also there. But, so that's the reason why I would like to request you, so I may leave after this inaugural session. I think people will understand me further. And then I have very strong connections with Nirella, my mentor and my senior colleague, Professor N.R. Madhav Menon, with whom I was associated for a long time. And because whenever think of Kerala, the first person that would flash to my mind, none other than Professor Nilakanta Ramakrishna Madhav. So I fondly remember him, and it's my good fortune to work with him at Kolkata and also at NJA. When he was the director of NJA, I was a faculty and director in charge for National Eye University. And I request, and someone who Saraswati, when assistant professor, when she called me, I asked her about Professor N.R. Madhav Menon. And my association has produced a small book. There's recordings of a conversation with Professor N.R. Madhav Menon. And ultimately it was published as a Turning Point, Story of a Law Teacher. So I request the young generation of law students to go through that book. And today, the dignity that the law graduates, law teachers are enjoying, particularly the National Eye Universities. Because this National Eye University is the idea of Professor N.R. Madhav Menon. So there is nothing wrong. If I remember Professor N.R. Madhav Menon, because he studied in Government Law College, Trivandrum, and I thought that this was the college where he has studied. And please read that book. So that's the reason why, even though we have a program in our university, I could not resist the invitation from Kerala Law Academy. So, good morning to one and all. The Professor Jay Kumar, the former Vice Chancellor, N.K. Jay Kumar, and also they have another J.F. Jay Kumar, my good friend from Usmania University, and member of our research committee, Professor Jeeva Nirella, and Natarajan Narayanan, and many other dignitaries, teachers, and my student friends, participants from many other colleges from around India. So it's a difficult task to deliver a keynote address, because in any musical instrument, the keynote will be the last one. But however, the keynote will be in tune with all other ragas. Earlier, whatever the ragas that are tuned by the musician, keynote will absorb in each and every raga. So, my senior, Professor N.K. Jay Kumar, in his simple speech, he has exhaustively covered everything, leaving nothing. Because he has touched religious freedom, he touched human rights, he touched the secularism, and everything relating to the topic he has touched. But however, I would like to supplement, and Professor Jeeva Nirella has given the entire picture of religious freedom that is in operation and forced, and along with the statistics. And she has given a very good picture about the religious freedom in Sri Lanka. So I would like to share some of my thoughts about secularism and about religious freedom. And this program started with a dance. And the dance saying that, speaking that about Kashmir, that is regained Kashmir. There is nothing like regained. We never lost Kashmir. Of course, we lost one third of the Kashmir. It's only a matter of time that will be recovered. And so the beautiful dance, it's a secular dance. Why I am saying this is a secular dance? I think that the girl representing Hindu religion and showing the cross during her, and then speaking about Jannat. And I would like to tell, it is not only Kashmir. Each and every state has its own beauty, and each and every state is a heaven. For that matter, Kerala is one of the most beautiful states, God's own country. And Rajasthan deserts, sand dunes have their own beauty. And thick forests in Madhya Pradesh and Chhattisgarh, wonderful waterfalls have their own beauty. Karnataka, Andhra Pradesh, Telangana, each and every state is having its own beauty, and each and every state, for that matter, the whole India itself is a heaven. So, further, here I would like to tell certain things what are not regularly discussed by the academics, by the media. And just I would like to touch upon, because today's program started with Kashmir. And we are saying since 1976, India is a secular state, India is a secular state. Undoubtedly, even before 1976 also, India was secular, India is secular, and India will remain secular forever. Because it is not because of the constitution, because by virtue of the nature of the tendency and adaptability of this local population, India remained secular. And here, I would like to say a couple of things. As I said, that which are not in the media, never covered in the media, never discussed in the academic circles. As India was declared secular by the 42nd Amendment in 1976. And how this secularism, overnight India was declared secularism, I will come to it later. Let me start with Kashmir. So since 1976, the 42nd Amendment, which declared India as secular, whether anyone ever gave a thought that the 42nd Amendment was applied to the state of Jammu and Kashmir? No. So, if we have to say correctly, before 5th August 2019, when this Article 370 was withdrawn, we should have said India is a secular country except the state of Jammu and Kashmir. Because the word secularism was never extended. The 42nd Amendment, which brought the word secularism into the preamble of the Constitution of India, this word secular was never ever extended to the state of Jammu and Kashmir. And India remained a secular from 1976 to 2019, except the state of Jammu and Kashmir. Why? When the question was put to some of the Indian prime ministers, they said that because this state of Jammu and Kashmir, the majority population, they are not Hindus. If I remember correctly, the view of the government was that if we extend the phrase secularism, we extend secularism to the state of Jammu and Kashmir, it may hurt the sentiments of the majority of the people. This was the reply. And ultimately, since 1976 to 2019, this concept of secularism was never extended to the state of Jammu and Kashmir. And only from 5th August 2019, legally, we can say that India is a secular nation or a secular country. Okay. So, this 42nd Amendment, why this was not extended to the particularly the concept of secularism, why the state of Jammu and Kashmir was not declared a secular state due to certain political reasons. Beyond this, I don't want to venture because there's so many other things if you want to speak about the state of Jammu and Kashmir. Anyway, let us look into this concept of secularism. And undoubtedly, this was discussed because when we want to speak about this religious freedom, particularly in the context of India, because secularism means different things in different parts of the world. And India is the country which has declared itself as secular in its constitution. And you will not find in other constitutions, some constitutions they declared Islamic constitutions or something else, but some constitution they didn't say anything about secular or unsecular or religion or something else, including the so-called developed nations. But by and large, most of the developed nations, you may say UK, USA, or European countries, they are secular in nature. But there is a difference of secularism in India and there is a difference of secularism in the United States of America. Okay, so let us come to the secularism concept, how this was entered into the constitution and why the Constituent Assembly at the time of drafting of the constitution, Indian constitution, they are well aware that India is a secular country and there is no doubt in it. In spite of so many invasions, so many right from 6th, 8th century onwards, the Arabs invasion on Sindh. India means, don't think about India of 1947. India is right from the present Pakistan, Bangladesh, and up to Burma. And this country, there were despite of all these invasions. And India has accommodated, India has absorbed wounds and all sorts of invasions. In spite of that, India maintained its identity. The native people, they maintained their identity. And though Dr. B.R. Ambedkar, a great scholar, he knows, if you see his last speech in the Constituent Assembly, I think on 24th November 1948, just when the final draft was submitted to the Constituent Assembly, he delivers an excellent speech. What is scholar Ambedkar, who can see the personification of scholarship and the changed personality of Dr. B.R. Ambedkar, where he has reviewed the Indian history right from Aryans, right from Hindu civilization till 1947. That means why I'm saying the members of the Constituent Assembly, they are well aware that the people in India, the native people in India, they were secular, they're always secular, even if the word secularism is not inserted in the constitution, but the society and people of India, they remain secular. Probably the reasons why they have not declared India as secular in the constitution, as we see section 25, as Professor Jaykumar has already referred, that 25 of the Indian constitution provides for religious freedom, and also it also provides for the state to interfere in the religious affairs. So if you look into Article 25, subclass 2, subclass A, it is for the state to regulate, restrict economic, financial, political, and other secular activities. So today, Tirumal Tirupati Devasthanam or Padmanabha Swami Devaswam Board, and many other places. There are religious and charitable endowments act by the states. So these are the Article 25. These are the articles which empower the state to interfere in the religious activities, in the management of the temple boards. And of course, apart from faith, these temple boards, they also deal with other activities. So that's the reason why state interference in the religious activities is provided in the constitution, because we cannot anticipate in India, state is not totally deviated from religion. The constitution itself has provided state interference in the religious matters, in the sense that the matters relating to financial, political, and other secular activities. Further, the Act has specifically provided to interfere, the Constitution has specifically provided, empowered the state to enter into the religious realm of Hindu religion. How there are certain bad practices, what we may call, and Indian Hindu temples, they are not open to all. For a section of people, they were prohibited from entering into the temples. So, subclass B of clause 2, providing for social welfare and reform, or throwing open to Hindu religions institutions of public character to all classes and sections of Hindus. So this is another clause in the constitution which gave powers to the state to bring reforms in the Hindu religion, and practices. So also section 26, Article 26 provides for this freedom to manage religious institutions. And above all, we should also look into the Article 290A, that is annual payment to certain Devaswam boards. That is, a sum of 46 lakhs and 50,000 rupees shall be charged on and paid out of consolidated fund, that is from the government funds to the state by the state of Kerala every year to the Travancore Devaswam board. That is, from the state funds, the government of Kerala has to pay a certain amount, some 46 lakhs something, 46 lakhs 50,000 rupees to the Devaswam board. And similarly, the temple in Tamil Nadu, the government of Tamil Nadu also has to pay some amount to the temple. So that is consolidated fund, means it is the public fund, that is the amount collected from the public. That means what I would like to impress upon is that the members of the Constituent Assembly, they are very much aware about the secular nature of the Indian people and the Indian society. But however, they have restrained themselves in declaring India as a secular state, because there are certain articles which has given the power, that is, the state is not totally divorced from the religion as far as India is concerned. The state has vested these certain powers. So probably this is my opinion. Why the Constituent Assembly? Because the Constituent Assembly represents the members, and the Constitution reflects the collective wisdom of the members of the Constituent Assembly. So probably these may be the reasons why the Constituent Assembly, under the drafting committee particularly, Dr. B.R. Ambedkar restrained himself from declaring India as a secular country, even though secular nature is part of Indian civilization and culture, because every invader was absorbed in the Indian society. And as Jeeva Nirella Professor has said, that it has become a beautiful garden with all flowers. And being the students of law, because if we are not going to do the research, who else we do, because doing research is the nature imbibed in the education. So just I would like to throw some aspects regarding this secularism. So overnight India became a secular country. Overnight India became a secular country. And because the young generation of the nation, the future lawyers and judges, and Rajnarayan, he challenged, just going back some into 1970s, just before emergency, Madam Indira Gandhi, she contested, and the opponent was Rajnarayan, and he challenged the election result because Madam Gandhi, she has misused her powers and resorted to malpractices in elections. And ultimately, the election was challenged, and Allahabad High Court declared her election as invalid. That is, her election was unlawful. And time was given to go to the Supreme Court. And in the Supreme Court, Honorable Justice V.R. Krishna here, it was a vacation court, and he upheld the invalidity of the Allahabad High Court decision, saying that her election was invalid because she resorted to some election malpractices. And with all good intentions, Justice Krishna here, though he invalidated the election, but she was allowed to continue with a good hope, that she may, the Congress party may change the leadership. But what has happened in 2 days, Madam Gandhi, she declared emergency. And during the time of emergency, she brought this 42nd Amendment, and overnight, there was no substantial changes in the Constitution, and sovereign and socialist, these two terms were added to the preamble, and India was made a sovereign socialist secular democratic. And I'm not pointing out that adding secularism is a bad thing. I'm only questioning the procedure. If we say that this is valid, then we have to say that emergency is also valid. And whatever she did during the time of emergency, we have to endorse all those things. So I have gone through the parliament debates at the time of when this 42nd Amendment, and in particular the discussion in the parliament. And there was no demand. And because Madam Gandhi, the way how with all autocracy and aristocracy, no one could oppose her in her party. And everybody started making the bhajan, yes, we have to do this, we have to do that. And even no proper thorough debate. And the debates in Constituent Assembly about secularism were much richer than the debate that happened on secularism in the parliament. So, my friends, I would like to say that when we are discussing about India is a secular country, these are the other facts. These are also need to be discussed. I'm not saying that, I'm not on this side or that side. Just I'm throwing the issues. Because if we, in the law schools, if we are not going to discuss, though this is history, we are not going to put the clock back. But definitely we have a right to discuss and debate, and if necessary, even to judge what happened was right or wrong. And so my submission here is that when we can unilaterally declare India a secular country in an undemocratic way? If in a democratic way, what is wrong if we declare common civil procedure code? Democratic way in the sense that I'm not saying that it should be a Hindu code or Christian code or Islamic code. Let there be scholars from Hindu, Muslim, Christian, Jews, Parsis, and let them come to a common conclusion that in order to protect the civil rights, in order to political rights, religious rights, the inheritance, marriage. So for all this, as I said that yesterday, the day before yesterday, the Kerala High Court has declared marital rape. But there's also, the honorable judges, they have highlighted the sexual perversion, certain things which are not acceptable to any woman. So in keeping that, the statement was in that context. Contextually, we have to see, not to generalize that. In this context, I think that this is high time. I'm not saying that this should be a Hindu code or Muslim code or Christian code. It should be a common code. So when we could have a secular country, then we should also have this kind of what you call common civil procedure code also. And I hope that sooner or later we'll become more wiser and adopt for common civil procedure. And then another problem today that we are facing and discussion, and we heard that the invaders has destroyed Hindu temples, this and that thing. And in 2021, the idols in the temples, they were destroyed in the state of AP. They are not invaders. They are not coming from Afghanistan or Pakistan. They are within the state and they are doing all these things. Just, I'm not saying that this thing, I'm only bringing the facts to the notice. And law will take its own course. That's a different story. And when we are, the other issue that's bothering the nation is regarding the conversions. And as rightly pointed out, under section, Article 25, there is also freedom of religion even to practice and propagate. Some members in the Constituent Assembly, they demanded that along with propagate, there should be the right to conversion. But however, after thoroughly debating the religious freedom, the members of the Constituent Assembly, they denied to include the right to conversion, that is extension of religious freedom to practice and propagate and conversion, the word conversion, but still the conversions are going on. So if it is a major with all his consent, believing the philosophy, having faith in another religion, if someone converts, there is no issue at all. But taking advantage of the economic condition, the gullible poor, as earlier scholars said, that the vulnerable communities like backward classes or tribals or scheduled castes, by alluring them by bribing or something else under force, threat, if such conversions takes place, it is wrongful. So conversion is a major issue or a minor issue, or we should push it under the carpet. It all depends on, everyone will have their own perception. In some states, they consider that like UP, conversion is a very big issue and they have made their own law. In AP, people do not bother whether someone converts or someone doesn't convert. They won't make much, it won't make much difference for others or for the political leaders. So it all depends on the political party, their way of dealing with the people. And so if we look into the different, each political party is having its own perception of its religion. And communists, they won't believe and another party they believe in temples, and other party they want to maintain equidistance with the temples, churches. So this is the complex issue, and this complexity is the beauty of India. Everywhere, anything, if we raise, there will be a problem. And India is the only country where people enjoy the maximum freedom. Maximum freedom, not only for religion, in every aspect. One can say the Prime Minister, Punka Dalal, or many other things. And decharge me or something else like that. And this unparliamentary abusive language, nowadays some political leaders they are using. So as far as in India is the country where, along with all freedoms, religious freedom is also there. And if at all there are any violations for religious freedom, it's only an aberration. It's only an aberration, because no law restricts, or no chief minister can restrict the religious freedom of his own people. So this is, India is a robust democracy, and fortunately, the people of India and the governments, they are governed by a beautiful constitution. And the unity of India, in spite of different languages, races, castes, subcastes, and all, the unifying factor is the Constitution of India. And we have to pay our rich tributes to the members of the Constituent Assembly who has drafted such a beautiful constitution. If there is a failure in the Constitution, as Dr. B.R. Ambedkar said, that absolutely there is no failure in the Constitution. It is only the people who are implementing the Constitution. If the Constitution may be in the hands of good people or bad people. So automatically, if it is in the wrong hands, there is a possibility of abusing. Otherwise, we have a beautiful Constitution to preserve, protect the fundamental rights, and along with all fundamental rights, we have the fundamental right of religious freedom. And I don't think so that there is any threat to the religious freedom in this country, because we have a strong judiciary, a vibrant judiciary, which could protect the fundamental rights of the people of India. And I'm very grateful, because the topic is such unending. You can speak hours together by taking it to end. Again, recent times, there is interference in the religious affairs, whether it is Swami Ayyappa temple, and in 1960s itself, what are the essential practices of the religion, what are the non-essential practices. A big debate is going on. A big debate is going on. The courts, they can interfere in the non-essential practices of religion. So I'm not venturing, because I'm trying to restrain myself. As you call that, irresistible impulse is provoking me to speak many more things. But as this is not the time, definitely, just I want to throw certain issues. And you can also, the young students, they may also do research. What are the essential things of a religion, religious practices? What are the non-essential things of a religious practice? And this discussion and debate will keep goes on. And as I said, that this is an unending topic. And I have shared randomly, because this is not a structured speech. My random thoughts I have shared with you people. And thank you to the Kerala Law Academy for giving an opportunity to remember, recollect my mentor. Though I am not a direct student of Professor N.R. Madhav Menon, I was his colleague, and he groomed me, I can say. From a young lecturer, he groomed me, and today what I am, I can go to Professor N.R. Madhav Menon, and I dedicate this my speech to also Professor N.R. Madhav. And thank you very much. Thank you, Gokul.
Thank you, sir, for your valuable words. We are truly enlightened. Now, we have Professor Dr. S.P. Singh, Dean of Social Sciences, Chanakya National Law University, Registrar, Chanakya National Law University, Patna, with us. Let me welcome Professor Dr. S.P. Singh for the keynote address. Sir, please.
Thank you. Respected Professor N.K. Jayakumarji, former Vice Chancellor Nvals, Professor S. Sri Prakashji, my guide and philosopher, presently Vice Chancellor of DSNLU Visakhapatnam, Advocate Nagarajji, Director, Kerala Law Academy, and other dignitaries on the virtual dais and off the dais. It's my privilege and I feel deeply honored to be here on the 8th International Conference on a very pertinent topic, that is on the recent trends in human rights and changing facets of religious freedom. Dear friends, almost everything is discussed by our two learned professors, Professor N. Jayakumarji and Professor Suraj Prakashji. Just I want to give some footnotes about this very topic. Today, what we are talking about, the human rights, it is not a very easy gift today what we are enjoying. So many bloody wars of religion were fought in world, particularly the European countries, between the religious leaders and the kings for the matter of supremacy. Ultimately, the ramifications or what we got, it is the human rights. What we achieved, that is democracy has started creeping in. In France, liberty, equality, fraternity has started. And human rights and non-religious, religious free, a democratic right, political rights also started coming. Today, keralalaw, a French jurist, talked about the first generation of human rights. That is nothing but it is of liberty. Second generation of human rights, what we discussed, that is the equality. And the third generation of human rights, what we discussed today, is of the fraternity. So what things have been discussed? What we got that is relevant today? Because human rights are not the things which are given by the government of the day. Rather, it is the duty of the government to protect, preserve, and defend our fundamental human rights, to express ourselves, so that we can be a good human being, we can understand the things. And in order to live in a dignified life, when you see the Article 21 of the Indian Constitution, which talks about that no person can be deprived of his life and personal liberty except according to procedures established by law. And Article 13, Clause 2 also talks about that no laws can be made which takes away the rights which have been enshrined in this very part, that is the part 3 of the Constitution. So it is not, it is beyond the hand of the political parties who come into the government, because human rights can't be taken away. It doesn't depends on the vicissitudes of the government. And that's why we have Article 32 also, which is known as the heart and soul of our Constitution. Because if anyone is going to take it, then we can go to the Supreme Court. That is also a fundamental right in the Indian Constitution. And B.R. Ambedkar used to say that it is the heart and soul. And our Honorable Vice Chancellor, Professor Jayakumar, also discussed about the basic features. So it also comes under the basic features, no one can take it. So these are the important things we have to keep in mind for the human rights. So far as religion is concerned, a state should not intervene in the matters of the religion. When you see the first amendment of the American Constitution, that is the establishment clause of the religion, which says that a state should not interfere. A state should not practice one religion or any other religion, or should not give any aid to one religion or all religions. It is the duty of the persons, the communities, how they feel, how they do for the religion. A state should not interfere. That is the most important. What we are finding today, that it is the point this should be taken care of, because it is disturbing the mind of the masses that the state should not interfere. Our country is very secular. What our Professor Suji Prakash talked about of the 42nd Amendment. Even before this, we have very solid democracy. You see, in 1971, when India was a part, India helped Bangladesh to get liberation from the Pakistan. Then Indira Gandhi was very famous. Atal Bihari Vajpayee used to say that Indira is the avatar of Kali. But the same Indira Gandhi, when she proclaimed emergency, then she did not win her own seat. So democracy is very, very dependent in the Indian soil. It is, you see the neighboring countries, whether it is Sri Lanka or Pakistan or Bangladesh, constitution failed. But we have made the constitution in such a way, it's such a bouquet that every flower is blooming. So we are proud of our constitution. So far as religion is concerned, what we discussed about the establishment clause of the religion of the America, you see the case of the Davis versus Mason. It also discussed that what is religion? He discussed in this very case that religion is a personal thing. To whom I worship, how I worship, what do I practice? It is by internal things. The state doesn't come into picture. When you see our Indian Constitution also, Article 25, which talks about subject to your public order, morality and health, everyone has a freedom of conscience and to freely practice, profess practice and propagate religion. What does it mean? When we talk about the conscience, we have the choice. What we feel, it may be wrong for others, it may be not good for others, but what I feel, because no one has seen the God, but we feel that it is the way by which we get the solace, by this very way we get the peace. If we are not going to disturb others, then what is wrong in it? Why the majority or why one will say that you have to practice like this, you have to eat like this, you have to clothe like this? A sweet will. I want to live in a dignified way. And when we are going to profess, it means I want to say that what my religion is, but I should not force. When you see the case of Ratilal Parachanda Gandhi versus the state of Bombay, in which it is very, very clear that everyone has the right to go for the profess practice and profess what religion you believe. In the case of Stanislaus versus state of Madhya Pradesh, it is also there that without allurement or inducement, one can profess. You don't have to force. But dear friends, when we are going to profess, then someone will be induced. How can they come? When others will know about the religion of others, then only they will come to know. I am a born Hindu. I may want to be a Christian. I may want to be a Muslim. Any born Muslim wants to be Hindu. So when one knows the things about other religions, then only he can be there. But conversion, anti-conversion, if anyone on his own willingness, if anyone wants to be converted into other religion, what is wrong in it? When you see the Article 12 of the European Union, it says that you can go for the conversion on your sweet will. Voluntarily it should be there. No force should be there. No coercion should be there. But here, when the majority is there, if anything is going to happen, then you are going to make case or this way or that. In the very famous case in Ulitha Hyde versus the state of Odisha, Supreme Court has made it very clear that conversion is also a part of the Article 25. Without it, there is no professor. There is no professor. You can't profess. So this thing in the majority government, it should not be that what I feel it is not the work of the government to decide that whether any person wants to change the religion or not. It is the sweet will when he has read, when he has learned the things about the other religion, if he feels. So we have the chance at the same time to be in my own religion or to go to another religion. When you see the Article 12 of the American Conventions on the Human Rights also, it talks about it. So everywhere, the UDHR, Universal Declaration of Human Rights, Article 18 talks about it. So everywhere it is discussed. And it was not a case some years ago, but right now it has become a very pertinent case. So many FIRs have been lodged if anyone wants to go voluntarily to change for the conversion, what our Professor N. Jayakumar have also discussed all these things. I'm also happy that in the Sabrimala case, Supreme Court has shown the way. It talks about the gender equality, that men and women of any age can enter the Sabrimala. But see the beauty of the Supreme Court, still it is the sub judice matter. In Ram Janambhoomi case, this case was not resolved for so many years, but the Supreme Court has resolved. It is also a very good thing. Supreme Court intervened, and it is the beauty that we achieved some peace among the nation, among the people. I am also the votary of the Uniform Civil Code, which talks in Article 44. And B.R. Ambedkar and others also believed in this, because it also talks about the, it goes against the gender discriminations, because the marriage, the divorce, the transfer of property and other things, it should be for all. It should be secular. When you see Article 25, Clause 2, it is the only place where secular word was used before coming to the preamble, before the 42nd Amendment. So I am the opinion that religion should be there. Everyone should practice if he feels, but it should not be forced that if I want to be changed or if I don't want to be changed, it should be the sweet will of the person, of the individual or the communities. The state should not interfere. But I'm sorry to say that even right now, the judiciary plays, it works under the pressure. I don't know what place is there. In order to maintain peace, religious people should come together to discuss the things. Now it has become a practice in the United Nations also. The Commissioner of the United Nations Human Rights had called a meeting of all the religious persons because they have the good rapport with the persons of their own religions. In this very way, terrorism or gender injustice or social injustice can be controlled. When they make their things to their people, then they come round, they understand that what is wrong, what is right. We don't have so much approach by the politicians, but these leaders, these religious leaders can have easy approach. So we can control by taking their support also. And it happened many times in India also. So I don't want to become a wall between lunch and this session. So I will say in conclusion that religion should be kept only individual. The state should not interfere. The state should not intervene. Whenever people wants to change from this religion to other religion or from that religion again to this religion, it should be mandated. It should not be forced, or a state should not interfere. Thank you once again for calling me to be invited for this very prestigious international seminar conference. And also at the last, I am thankful to Dr. Dakshita, who approached me for this very conference. So thank you very much.
Thank you so much, sir, for filling us with the awe and joy of your wisdom. Now we have Professor Dr. Y.F. Jayakumar, Dean, Research Council, Maharashtra, National Law University, Aurangabad with us. He has a teaching career spanning over 30 years. He's an eminent personality with authoritative knowledge in the field of law. I welcome Professor Dr. Y.F. Jayakumar for the special address. Sir, please. Sorry, due to some contingency, Professor Dr. Y.F. Jayakumar, sir, will not be able to join us. Moving on. Gratitude is not only the greatest of the virtues, but the parent of all others. says Cicero. I welcome Arun V. Unitan sir, Assistant Professor, Kerala Law Academy Law College, and one of the faculty conveners of this international conference to give us the vote of thanks. Sir, please.
Thank you, Gokul. Am I audible?
Yes, sir, you are audible.
Okay. Greetings of the day, one and all. Respected dignitaries, faculty members, students, and dear participants. It's my privilege to be enshrined with the duty of extending gratitude to all those who have made this international conference reach its epitome success with the presence of the esteemed personalities. Firstly, I would like to extend my heartfelt thanks to Dr. N.K. Jayakumar sir, former Vice Chancellor, Nuals, Cochin, and the member Executive Committee of the Kerala Law Academy Law College, and an iconic Indian law educator and an eminent jurist. Sir has always been a constant source of motivation and has paved ways for us to work hard and stay focused on our goals. Thank you, sir, for your inspiring words. Thank you, sir. Next, I would like to thank Deshabandhu, Professor Jeeva Nirella, Madam, Department of Public and International Law, Faculty of Law, University of Colombo, Sri Lanka, who is having vast teaching experience for more than 25 years. And Madam is a renowned author of many books and articles with reputed national and international publishers. Thank you, ma'am, for your thought-provoking speech and enlightening us with the information that the situation that exists in Sri Lanka. Thank you, ma'am. Now, I take this opportunity to express my sincere gratitude to Professor Dr. Surya Prakash, Vice Chancellor, Damodaram Sanjeevaya National Law University, Visakhapatnam, and former Vice Chancellor, Maharashtra National Law University, Aurangabad, and Professor of NLIU, Bhopal, for enlightening this audience with your words of wisdom. Thank you, sir. I would like to express my sincere gratitude to Professor Dr. S.P. Singh, Dean, Social Sciences Department, Chanakya National Law University, Patna, for your deep, in-depth analysis and the keynote address. Thank you, sir. I would like to express my profound thanks to Dr. Y.F. Jayakumar, Dean, Research Council, Maharashtra National Law University, on this occasion. Now, I would like to extend my heartfelt gratitude to late Dr. N. Narayana Nair sir, the founder of the Kerala Law Academy Law College, who remains a constant force and a source of inspiration for all of us in conducting all kinds of academic activities in this college. Now, I would like to pay my gratitude to Advocate Nagaraj Narayan sir, Director, Kerala Law Academy Law College, who has always been a fountain and constant support to all the activities in this college. I am indebted to you, sir, for being a catalyst that stimulated us to do our best and for standing as a pillar of strength. With deep sense of respect, I thank Nagaraj sir for his untiring effort. On behalf of the Kerala Law Academy, teachers, students, non-teaching staff, and also on my personal behalf, I thank Dr. Nagaraj, Advocate Nagarajan sir. Now, I would like to thank Dr. Lakshmi P. Nair, Madam, Research Director, Center for Advanced Legal Studies, KELSA. She's a person with a distinguished thought and innovation. She has been a constant support for all the academic events conducted in our college. Ma'am, on behalf of the entire Kerala Law Academy family, I extend my sincere thanks to you. Now, Professor Harindran sir. Professor Harindran, our principal, is always a source of inspiration to all the academic activities that is happening in this college. He extends all his support and guidance to all the competitions, conferences, international seminars, and workshops organized in this college. On behalf of Kerala Law Academy, teachers, non-teaching members, and on my personal behalf, I extend a sincere thanks to Professor Harindran sir. Now, I would like to take this opportunity to place on record my hearty thanks to Professor Anil Kumar sir for providing constant guidance for the conduct of this conference. I thank you, sir, for helping us to manifest our abilities in ways that we could never have imagined. I also like to express my immense gratitude to my co-conveners and the faculty colleagues, Dr. Dakshina Saraswati, Advocate Arya Sunil Paul, Ms. Radhika RP, for their constant hard work and support which was integral for the success of this conference. I would like to extend my gratitude to all the faculty members of Kerala Law Academy, our dear student conveners, moderators, for their tireless efforts for the smooth conduct of this international conference. Finally, I express my regards to the participants of this international conference from the different parts of the country for making this event a grand success. Your active participation has helped help this event to reach the epitome of success. I conclude my words by extending my deepest gratitude to all of you. Thank you. Thank you.
Thank you, sir, for expressing your heartfelt vote of thanks to this inaugural session. With that, we have reached the end of this inaugural session. Hope we will be able to derive the best out of this conference to establish harmony between human rights and religious freedom. Thank you all for your kind cooperation and patience. This is GS Gogol signing out. Once again, thank you all.
Thank you.
Thank you.